Item 21.
Otherwise, it was ready for hearing again.
Yes.
Therefore,
Yes. I will have to file a substitution appeal.
heard Mr. D. Pangin, the knowledge council opinion and drop of the opinion. And also heard, is there? No. So,
He's
okay.
not here.
It is submitted by Mr. Pangin that the appellant expired during dependency.
Yes.
The appellant expired during dependency of the appeal, and hence the substitution petition has to be filed to substitute the legal heirs of the appellant.
Right.
For substitution. You need how many times? Because you have to collect the addresses and all the names and
3 weeks.
which after 3 weeks accordingly, enabling the council for the appellant to file the necessary application in this way.
Okay.
Ma'am, please, ma'am. My lord, I beg to mention item number 9, 10, 11, and 12, my lord.
9, 10, 11, and 12.
12, yes, ma'am.
Yes, what happened?
My lord, the investigating officer, my lord, who was investigating this particular cases, my lord, he has been transferred, my lord, out of the SIC, my lord. So,
in all these cases, what the CD was called for? Or
no city, my lord, the records,
Huh?
the status of the case.
status of the
Is, but then since he's been transferred out from the SIC, my lord, so a new officer has to be engaged. So as of now, I don't have the status of the case. Therefore, my lord, I'll inform the concerned OCPS, my lord, so that I can get the status from the new IO.
I mean, the officer who was investigating, he got transferred.
Yes, my lord. He was in the SIC, so he has been transferred to the regular police station. So a new officer has to be appointed. 3 weeks time, my lord, then I'll produce it.
Otherwise, the cases were in orders column. Why? But those cases were in order column. Is there any?
No, because the status
No,
of the case.
that's what I'm asking, because there are other respondents also.
No, my lord.
Other opposite. No?
No, my lord.
5 others. Who are they?
5
In all
others.
these matters, so and so, and state AP, and 5 others, and 5 others. What? Now, give me one. 9. I don't remember. Okay, affidavit in opposition.
My lord, here I am representing 1, 2, 3.
1, 2, and 3.
Yes.
Uh,
Number 5 is the, I think 5 and 6 is the complainants, madam.
they are private.
Yes, madam.
But from the office court, most probably.
But as far as my lord,
The service is completed, but Wakalatnama has not been filed most probably on behalf of 5 and 6.
yes. But then, my lord, since it pertains to a PC Act, and then we are investigating their performer respondents, my lord.
And the petitioner side that representing you. You are on behalf of Mr. Titi Tana, or you are appearing now?
Appearing once.
What's your good
B.
Pichai is? Hard Mr. B. Pichai, in all same order will be there. The learned counsel for the petition also had the special PP, Mr. Upada, the other Pusta, further, it is submitted by the special PP, Mr. Okada, that the investigating officer SIC has already been transferred, and he was supposed to give the status report of all these cases, and accordingly needs some more time to get the status report from the newly posted investigating officer. Further, it is seen from the office note dated 29/1/2023 2024.
Three weeks, ma'am.
Was there any interim?
No, no. Oblige. May I please, Lordship? Lordship, I beg to mention item number 3 and 4, Lordship.
Item number
3 and 4. I am for the respondent in both the cases. So, Lordship, may I humbly pray that matter may be listed on 27 February. I have some
additional
personal.
column.
Yes, Lordship.
You are for the petitioner?
No, Lordship, I am for the respondent in both the cases.
I'm for the petitioner in item 3.
In item number 3, you are for the petitioner. And item number 4, Mr. Panging was there. He
Yes,
left only.
he is in the court one. I already informed you.
Why you need the adjournment?
Lordship, I'm sorry to tell you, till yesterday or day before yesterday, only I received a prepaid instruction from client.
Hard Mr. Number 3 over Mr. D. Sophie and number 3 for the petitioner. And then number 4, Mr. D. Panging, the learned counsel for the petitioner. And in all 2 cases, Mr. K. Lolen is the for appearing for the respondent. State is also there. Hard so and also hard MSL Hadi, the learned additional PP appearing on behalf of the state respondent. It is the request made by the learned counsel for the respondent, Mr. K. Lolen. The matter has been adjourned. How many weeks you need?
On 27th, that may be given.
Fixed date.
27th.
Let the matter be listed on 27th, 2000.
Yes.
In admission column.
Lordship, I beg to mention item number 22 on behalf of Titi Tara. Matter may
Item
be
number?
22. Matter may be fixed on 25th, 26th of this month.
Why he
Uh,
is
taken
not
as,
present today? Mr. Tititara is not present today.
He's there, but his some personal difficulties. He couldn't appear today in this matter.
State is there.
Concern has been
Otherwise,
taken.
criminal appeal, this paper book is also ready.
Yes, sir.
At the request made by the on behalf of the MP's counsel, Mr. Tititara. The case has been, the case is adjourned. However, it is submitted by the learned additional PP, Mr. Tititara, that paper book is ready and case is ready for hearing. For the stop. 1-2 weeks will do.
Lordship, fixed date may be given 26th,
Huh?
26th of this month.
If you're taking fixed date and you are not in a position to argue the matter, then what will happen? 26th,
Oh, 27,
20,
27th of this month.
it will be listed on 27th.
Oblige.
I beg to mention item number 13,
1-3,
1-3.
Huh.
Uh,
you need adjournment, why?
because of some personal difficulties of leading counsel, we could not
There
prepare.
most probably special PP was there, SIT.
I have obtained
Ah.
taken consent. Matter may be fixed after 3 weeks.
Have you received any, it was under the
Under-
order column.
Yes,
Have you
ma'am.
received any case, I don't know, case record or
No,
anything?
nothing. ma'am.
Was there
I
any
think
order?
we have filed an affidavit to that effect, ma'am, against the
Give me the
petition.
item number 13. Item number. Affidavit in opposition is filed by. So you have already filed your affidavit in
Affidavit,
opposition.
ma'am, yes.
Why it is an order column? Is there any other respondent, etc., to be noticed to be served? and not
Actually, respondent number 2,
Hearing? We are on item number 22.
13.
1-3,
Okay,
1-3. You have given item number 13 or 1-3. This is item number 13 too? Oh. other
Respondent number,
respondent?
actually respondent number 2 was the inspector IO.
Ah.
And in the meantime, he expired. So, to that effect, they have, filed, affidavit citing that he died. So,
In affidavit, you have brought out.
Yeah, we have brought everything on record.
Mr.
Arkoyu.
R. Kohli, the learned counsel for the petition. I also heard Mr. Ajay Sethi, the learned special PP at SIT from office note dated 13/6/2023. It revealed that the respondent has already filed their affidavit in opposition. So then in that case has already been received. Let the matter be accordingly listed for hearing. Well, do you want any fixed date or
No, after 2 weeks,
after?
3 weeks.
After 3 weeks? Was there any interim?
Yes.
Then
Yes.
after 2 weeks, let the matter be listed after 2 weeks, interim be continued till next date of list.
Obliged, ma'am.
Obliged.
May I please, Manoj?
Mhm.
Manoj, I beg to mention item number 5, Manoj. On behalf of B Jamo.
On behalf of
B Jamo, Manoj.
is absent,
Yes, Manoj, leading counsel is absent. Out of station, Manoj, on medical ground.
a request has been made on behalf of Mr. B. Jamo, the learned counsel for the petitioner, stating that he is on leave for medical ground. Also heard the learned additional PP appearing on behalf of additional PP MS Al Hadi appearing on behalf of state respondent. Scanned copy of LCA has already been received. Let the matter be listed for admission following on the after 2 weeks,
After 1 week, Manoj.
after 1 week,
Yes, ma'am.
after 1 week.
Manoj, item number 8 also. Manoj.
Hmm?
Item number 8, Manoj.
Item number 8 also, Jamu was there.
Yes, Manoj.
Same
Yeah,
order.
we already received the CD also.
CD, it was a bill hearing.
Yes,
Yes,
Lordship.
ma'am.
AB is, we've
Then
already
we have to
received CD.
fix a date,
Can it be on Tuesday, Manoj?
next Tuesday.
Yes, Manoj.
Next Tuesday is a holiday, I think. Make
Monday
it on
ko na,
7th,
fifth.
Wednesday. Tuesday is 6th is holiday,
So on Monday, fifth.
Otherwise, Manoj, on Monday, Manoj.
Monday.
Monday, yes.
Your good name?
M. Doji, Manoj.
Mr. N. Doji, the learned counsel appearing on behalf of Mr. B. Jamu, the learned and this counsel for the petition, and it is submitted that due to medical ground, he is out of station. However, it is submitted by the learned additional PP and Ms. Al Hage that CD has already been received. Accordingly, list the matter on 5/2/2024. Retain the CD till next date of list.
Manoj, one more item, Manoj.
Hmm.
Item number 14 also.
Here also Mr. Jamu is there,
Yes, Manoj.
same order.
After
It will
two,
be after,
after 1 week, Manoj.
was there an interim and no?
No, Manoj.
At least after 1 week. And the request made by the late on behalf of Planet Council, Mr. V. Jamu, the matter be listed after 1.
Obliged.
Your Lordship, I beg to mention item number 15.
Yes,
May fixed on 13th of February.
why you need adjournment?
Actually, the senior counsel of station,
Who is your senior counsel?
Sunil Mao.
As well,
Yes, brother.
you are appealing for the private respondent.
Yes, ma'am.
Why is it in order?
No, I.
You are repeating only full respondents were there. State and focus. Can be listed for admission. Your miss
Sonam. Sonam.
as RMS so and so, the Planet Council appearing on behalf of ESMA, the Planet in this council. And also heard Mr. Planet Council appearing on behalf of Mr.
After 12, maybe on 13th of February. Your list, there is 13. Yes, there is the interim order, maybe 20.
May 7, my lord.
Okay. 23.
May 7.
Yes.
Lord, here I am challenging a search it, my lord. My lord, what happened in this case, my lord? Lord, I am, my lord, now presently, my lord, serving as a deputy director, school education, my lord. I'm as 59 years, my lord, due to be next year, my lord. And my humble submission, my lord, before I start, my lord, at this stage, my lord is really not ill, my lord, that at this age, my lord, all as my lord, harassment by the statutory authority, my lord, is really not allowed by my lord. Now, my lord, I am challenging a start for my convenience, my lord, election number, my lord, 47, my lord. 47, my lord.
Page number 47.
47. Election number 1, page number 47. This is my lord, important, my lord. What happened, my lord? While I was serving as ALO, my lord, as a DDSC, my lord, I was transferred prematurely, my lord. We didn't normally transfer guideline by the government is 2 years, my lord. I was prematurely 1 and before within 1 year and 1 month, my lord. Accordingly, my lord, I approached this number.
Is there any word like premature transfer?
Yes, my lord.
Is there any word like premature transfer?
Yes, my lord. When the
It is the government priority, na?
yes, my normally it is 2 years, my lord. As part of government guideline, my lord. Now I was transferred.
Our judicial officers get transferred even in 3 months.
Yeah, that is true. That is true, my lord. That is true, my lord. No, my lord.
Anyway, you
Well.
got transferred within 1.5 hours.
1 year and half. 1 year and 1 month, my lord. So accordingly, my approach, my lord, I avail legal remedy. I approach my lord. During my lord, what happened, my lord? My lord will see this 47, my lord. I was issue with this notice, my lord. This is important, my lord. Whereas a complaint is received against you for encroachment of government land and causing damage to government goals by art cutting, construction of your RCC building. Whereas this is important, my lord. Whereas, my lord, a sport verification, my lord. It seems, my lord, sport verification was done, my lord, was conducted on 8/8/22 and found that said one is on the bus of 4 laps. Due to art cutting, construction of your building, the government is in a precarious condition. Therefore, my lord, a direction was issued. You are hereby, my lord, directed to initiate immediate restoration, construction of protection wall, my lord, to protect the government and to confirm your construction within, my lord. My lord will observe 2 things here, my lord. Sport verification was there, my lord. I was directed, my lord, to construct a protection wall, my lord. These 2 things, my lord. Now, as my lord, I was noting to do it. I accordingly at page number 48, my lord, can you see? I informed the concerned authority, my lord. This is by deputy commissioner. I informed the deputy commissioner, my lord.
Number?
I informed
Page number?
48, my lord.
48.
48, my lord. I informed deputy commissioner, my lord. Inform you that you have mentioned the name of complainant who has made against me. May I know the complainant who is trying to wrongly implicate me in this case? It seems to busted an ulterior motive behind the scenes be by the very complainant. The fact of matter is that the complainant has misquoted my name without knowing the picture position. The residential building construction government Riken grandson of Sri Likar Kato, the LOT of the land, my lord. I clearly inform my lord, this is my Riken Kato, my son, my lord. And this LOT is my mother, my lord. I clearly inform, I have nothing to do with my lord. This is by the land is being occupied by my son and is allotted to my mother, my lord. I clearly inform, I have nothing to do with that, my lord.
No,
Now, my
you're-
lord.
You're the government employee, you are occupying the government quarter.
No, my lord,
No, notice was issued to you that you are occupying a government quarter.
no, my lord. What they are saying, my lord, construction activity in my supposed to my land, not in my position of my son, my lord, is my lord the construction of my lord say damage the quarter number 18, my lord. This is by
By your
other person,
construction.
my lord, not by me, my lord. Now I informed that I have nothing to do with it, my lord. Now 49 is land allotment, my lord, of to my mother, my lord. I am not indicating that this is my lord at 50, my lord, say my lord, this is Likar Kata, my lord. Srimati Likar Kata, my lord. Now, accordingly, my lord, estate number 53, my lord. This is Rikar Kata, my lord. I am reading past par only, my lord. With reference to above cited, I could like to draw kind attention of your page number 53, my lord. That notice up to see on this is wrongly addressed to Duken Kato as I Siri, my lord. Ram Kato is to person who is carrying out the construction activity of the RCD building near quarter number 17, my lord. He informed, my lord. I also clarified, or he also informed that it is my being. Now, my lord. My lord will see, my lord, 55, my lord. 55, my lord. This is by the principal, my lord. Page number 55 is certificate by the principal of the school, my lord. Page number 55, my lord. Saying that, my lord, no, there is no such, my lord. This is certified the boundary wall campus of government has been already constructed. There is no enforcement by the such and such, my lord. Now, my lord, thereafter, my lord will recall, my lord, yes, there was a direction, my lord, to construct a protection wall, my lord, by the authority, my lord, in the past notice, my lord, to me, my lord. Now, at page number 56, my lord. Married, my lord. Sir, with page number 56. With regard to above subject and reference, I would like to draw kind attention of your good office that I have completely constructed a retaining wall near government quarter which was damaged earlier due to necessary of territorial rain and negligent conduct of occupant of the same. Now, in terms of my lord, notice my order was given to construct the wall, my lord. He has constructed, my lord. My son has reconstructed the wall, my lord. In terms of the order by the government, my lord, he have constructed a boundary wall with a retaining wall, my lord. That was informed, my lord. Down below, my lord, see, my lord, that is duly received on 59/2020 by the concerned authority, my lord. Now, there's a direct allegation, my lord, of damaging the retention wall, my lord. Concerned authority, after verification, spot verification, directed to construction wall, my lord. Accordingly, wall was reconstructed, my lord. That was informed on 59/2020, my lord. Or 22, my lord. My lord, now, my lord, this become a close chapter, my lord. After, my lord, 10 months, my lord. This page number 57 was issued, again received, my lord. 57, my lord. 57. The undersigned shall verify the boundary of government school on 17/8/2023. Therefore, all the field staff under the establishment are hereby direct to accommodate undersigned to schedule date and time positively, my lord. This notice, accordingly, in terms of this notice, my lord, verification carry out, my lord. Verification carry out, my lord. Now, after wherein, my lord, some, my lord, the present private respondent, I have complainant, my lord, come in, also involved, my lord. Accordingly, my lord, this FIR, my lord, is 59, my lord. Page number 59, my lord. The body of FIR, my lord, will find it page number 62, my lord. Page number 62, my lord. Body of the FIR. This is by my son, my lord. The other accused, my lord, in this case, my lord. To the officer, FIR against such and such, such and such, such and such. With due respect, I could like to bring you kind notice on the incident that the 17 August occurred at the private residence of the underside. That I have got information of official visit of department land management at my residence on 17 August 2023. According, I was waiting for the official at the
FIR filed by your son.
my son, my lord. Yes, my lord. Yes, my lord. My lord. There was a order notice by the government for spot verification, my lord. According, I waited, my lord. Now, on the that day, my lord, instead of this official, my lord, the whole, my lord, I would say, my lord, the member of CAP Panchayat, my lord, like member come, my lord, and start to dictate it me. Even my lord, they tried to beat up son my son, but I was not there, my lord. I was not. According to this FIR loss, my lord. FIR loss against President Informant, my lord. Now, in counter to this, my lord, sorry, my lord, before that, my lord, yes, my lord, hold this, my lord, FIR loss, my lord. After lodging of the FIR, my lord, now we came to know that there was during the construction, my lord, of the wall by the mason, my lord, by the order of my lord, recall by the order of the authority itself, my lord, wall was constructed, my lord. During that construction of wall, my lord, there was a, my lord, some encroachment of 50 centimeter, my lord. Others said 80, my lord. My lord, 50 and 80, my lord. Now, if suppose person is constructing a wall, my lord, with a retention wall, my lord, there may surely, my lord, 50 centimeter, my lord, 80 happen, my lord. It not that I have a specific mechanical that measurement, my lord. It's by the mason, my lord, that will carry out the construction wall. Now, allegation, the verification said that, my lord, there is a 50 centimeter and 18. According to my son, my lord, at page 65, my lord.
You're going to forget about your son. Where is the FIR filed by the other side? Other side?
Other party, my lord.
64.
64 is, my lord, my application to concerned authority, my lord. If enforcement is there, my lord, by 15, 80, my lord, my son said, I will surrender, my lord, that land, part of land, my lord, to the concerned authority, my lord. Thereafter, my lord, this FIR, my lord, page number 70, my lord. Counter to, my lord, my son FIR, this FIR lost, my lord, page number 73, my lord. FIR start from 70, my lord, but then dear FIR, my lord, you will find a page number 73, my lord. May I read this, my lord?
Yes.
Subjects as FIR again, this is me, my lord. Now again, they have dragged my name, my lord, personally, my lord. So such and such for damage public property of government secondary school boundary wall and committing the offense of giving false information to the police and doing wrongful restraint during the time of official verification, my lord, 17 August, my lord. Now this is by private party, my lord, not by the government, my lord. They are saying that they most respectfully, we have the honor to inform you that on 17 August 2023, we, the other side, who happen to be a responsible citizen of Alo area, has visited the government secondary school premises to make verification of the area after receiving various complaints of the land encroachment of said premises. It is pertaining to mention that herein that we have visited the old school premises of the government higher secondary school Alo and have also visited the area of Sri Sas and Sas. This is me, my lord. After receiving a circular from the Land Revenue and Settlement Officer for joint verification of the school boundary and the encroachment area, and there were nothing illegal in our part because everything was done legally. But Sri Ridham Kattasas has misled the police station Alo by giving false information to the police, who is lead to registration of false criminal case against us at Alo PS number 743-47. Now, may I inform my lord that this FIR, my lord, has been finally indicted into final report, my lord, closure report, my lord, my son FIR, my lord, by the authority, my lord. It also pertaining to mention here that we have never made any trespass and our visit was fully legal because after obtaining a circular from DLRSA for joint verification, we visited the area. But we have been made as a criminal and accused by giving misleading information to the police. Therefore, your good office is hereby pray to register a criminal case against Sri Sas and Sas for giving false information intentionally and restraining the official team, including us. That another offense that committed by the Sas and Sas in his minor, again my name, minor, where damaged the public property, school boundary wall of government higher secondary school illegally encroaching the land, damaged septic tank quarter of Sas and Sas. The Sas has lost a FIR against us, sealed the above mentioned offense that have been committed him and his father. In view of, we ask upon your good office to register a criminal case against me, my authority. Now, my lord, this all start after 7 months, my lord. In terms of direction of the authority, my lord, my son is responsible. Now,
so is it this FIR you want to say that the FIR is filed as a counter FIR on the against the FIR filed by your son?
My son, my lord. Now, what happened, my lord? After that, my lord, I able AB, my lord. I cooperated with the investigative authority, my lord. So I cover. Now,
What is the stage of case, this stage?
Pardon?
Charge sheet has been filed or not yet filed?
Charge sheet, my lord. That is my lord. I did charge sheet. I have challenged, my lord. Page number 75, my lord. My lord will kindly see, my lord. It in extra 3.
Hmm.
Page no,
Your son is also one of the accused.
accused, my lord. This is start from 73, my lord, up to 93 is, my lord, the pub.
Yes, Mr.
My lord, without referring to any other materials on the record, my lord, if I may take my lord to page number 91, that would suffice the whole case, in fact, my lord. Page number 91 is the statement under 161 of the son, my lord. If I may read. The above name and address are correct as mentioned above. I am constructing the RCC building in the land allotted to my grandmother, Simiti so-and-so. The first boundary wall was constructed by so-and-so, which got damaged due to heavy rainfall. Then after consulting with principal of Government Higher Secondary School, Alo, self, then at my own cost, built boundary wall between boundary of Government Higher Secondary School boundary and the allotted land. After which, due to keeping of water syntax of about 2000 liters and 500 liters on the art field up portion adjacent and supporting the said wall collapsed. After that, notice issued by the Office of DLRSO to restoration of protection wall to protect the government quarters so and so. Then complying the order of DLRSO, I once again build wall, come retention wall at my own cost. He is admitting the fact that he has done everything, my lord. Therefore, I don't find any role of the father, in fact, my lord, at this stage.
Okay, will, at this stage,
Private parties are there, my lord. The notice has to be there.
otherwise you are on bail, I think.
Well, my humble submission.
No, you are on bail, I think.
Bail, my lord. My humble submission, my lord will kindly, my lord, stay charge sheet against me, my lord.
Stay the charge sheet.
My lord.
They are-
Charge sheet has already been filed and the case is at the stage of, do you have received any notice from the court?
My lord.
Charge sheet, as per you and as per the record, the charge sheet has already been filed.
Filed, my
The
lord.
case is at the stage of still appearance, charge for framing of charge or
My
what
lord.
is the stage?
My lord.
What is the stage of the case now?
Now, my lord, it is yet to be, that is pending conclusion by the London magistrate, my lord. Therefore, my lord,
Charge yet to be framed.
my lord. No,
In
my lord.
other words, we can stay the proceeding in respect of you.
My lord.
The other part.
No, yes, truly, my lord. In respect of me only, my lord. That's zero, my lord.
I think 207 has not been complied with yet. No summon, nothing, my lord, at this stage. No summon was issued,
Acha,
just
acha,
charge
yes.
sheet filed.
Just finish. And we can fix it if the staying of the case is also not required on the next time. If the notices are being served to the other respondents, the other private respondent, then at the administration stage or if we receive the copy, then matter may be heard on this.
Well, my humble submission to my lord, if my lord is my lord, 7 complainant is there, my lord. 7 complainant is there, my lord. To make them appear, my lord will kindly step proceed against me, my lord, so that they appear. Otherwise, my lord is their authority in the Alautan, my lord. I'm worried of that only, my lord. So to make them appear, my lord, in early disposal, my lord will kindly stay this proceeding against me, my lord, so that they can appear and we can finally argue the matter, my lord.
Heard Mr. Alpami, the Land Council for the petition. I also heard Mr. J. Sering, the Land P2 for the appeal on behalf of said respondent. This is an application on section so and so in connection with so and so. It is submitted by the Land Council for the petition that this land which is there was a construction on the land which is allotted to his son by his grandmother, and he is no way he is not the owner or nor any construction work was made by him. However, after receiving a notice from the government side, the directing to construct a protection wall, his son has already erected the protection wall and complying the order of the government side. Thereafter, with some false allegation of encroachment of the land of 50 centimeter. A group of people, who were they? The complainant, na?
Complainant, my lord, they are, my lord, member of my lord, who is young, some,
The
some, my, so, association, my lord, association of the area, my lord.
association in under which association they are? They, because 2 to 8 are the private respondents.
Yes, my lord, 2 to 8.
They are associated with which association?
Paktu Ao Youth Welfare Association, my lord.
Paktu,
Ao
Au
Youth Welfare
Youth
Association.
Welfare Association. Came to the place of the incident with lots of and lots of and at the gatherings of lots of people. They threatened my son and the other family member, for which my son had to lodge an FIR in the police station. To stop. As a counter FIR to that, the present FIR has been lodged by the present FIR has been lodged by that association.
Yes, my lord. Association.
That association with some false and concocted allegation, and including my name, where the involvement of the my name, including the name of the petitioner, though the petitioner is not at all involved in the alleged offence, nor the land and the house belong to him. The case is already charged against the present petitioner along with the other co-accused persons, and accordingly, petitioner full stop, and accordingly the present petition has been lodged by the petitioner, praying for washing of the FIR and other full stop. He further submitted that the age of the petitioner is at present 59 years, and further paid for stay of the further proceeding against the present petition, which is pending before. Would you know where case is pending at present?
CGM Alam, my lord.
Which is pending before the learned court of CGM Alam. Next, in this context, the learned PP has submitted that admittedly the land belonged to the son of the petitioner, and from the statement made by the son of the present petitioner as the co-accused, it under section 161 CRPC, it reveals that he already complied by the order of the government and also constructed the protection wall on the boundary of his allotted land. Next one, after considering the submission made by the Learned Council for both sides, I find it necessary to issue notice to the other private respondent number 2 to 8. However, no formal notice is required to be issued on the state respondent number 1. But in the course of the day, we give all the same. So, next paragraph. Also considering the submission made by the Learned Council for the petitioner and the nature of the allegation, I find that further proceeding in respect of the present petitioner be stayed in the criminal case number so and so pending before the Learned CGM so and so. So for the LCM, scan copy of the LCM, and there are lots of after 3 weeks of 4 weeks. 4 weeks, my lord. After 4 weeks. Issue notice koi diba? After 4 weeks. Hi, Lord.
My lord, this is an admission matter, and this matter was endorsed to one of the additional PP, but she could not make it today. So can this matter be taken up after 2 weeks, madam?
It was with whom?
With T. Genie, madam. Topi Genie.
Hmm?
I have endorsed that matter to other additional PP. Genie, yes, my lord. So she could not make it today. Okay, for some time.
She is
my lord.
not present today.
Not present today.
It will be listed after something. Sure. Your good name?
J. Koyo on behalf of Mr. T. Kamduk for the petitioner.
Madam, can this matter be fixed after 1 week, madam?
Heard Mr. J. Koye, the Learned Council, appearing on behalf of Mr. D.
D. Kamduk.
D. Kamduk. He is also not present.
He is present.
He's present, Your Lordship.
And also heard Mr. J. saying the Learned PP. However, it is submitted that the case is endorsed to the additional PP and STG, and she is not available due to some personal inconvenience. accordingly prayed for adjourning the matter for 1 week. They are allowed, the matter be listed after 1 week.
1 week. Obviously.
Your Lordship. Lordship, this is appeal on the order 43 for against against rejection of my order 9, rule 13 petition for setting aside the ex parte order. That's what it is. But the other side counsel has informed me that he's on the way.
On the way, yeah.
He's on the way, so he'll reach any moment. So after
After
a little while, Lordship, it's taken up.
But
Pass
I
over
I
matter.
just want to make it clear one thing, because we are having interview of this court, some process is there. So by 2:45, we have to rise.
No, Lordship.
So by the
Noted,
time he
noted.
comes, then it's okay.
Yes, definitely. Almost he reached.
Another 15,
Okay,
20
sure, for the time.
After, for a timing, yes.
Okay.
Please, Your Honor.
Because item number.
After 15 minutes, I think we can take up.
No, no,
15 minutes too long.
Okay, for the timing, we'll keep it.
Yeah, Lordship, we called for the scan copy of the LCR, Lordship. It is, has not been received till then.
Item number 6, we call for the.
LCR, scan copy, LCR, this is a regular way, Lordship.
Okay. Then have you received?
No, Lordship, registry has to call, Lordship. It has not received till then.
It's not received? Answer is not called for. As per note, office note, only steps taken for the respond number 2 is there.
Lordship, but last order, it was reflected, Lordship, in the order.
Scan copy of the LCR was called for, but
Yes, sir.
most probably registry has not taken any steps. And what about the respond number 2? Have you taken any steps?
Yes, sure. Oh, yeah, my lord, steps have been taken. Steps have been taken.
The steps are taken, actually.
From registry, Lordship, is, from registry also, Lordship, and from our, PP office also, we have taken the step, Lordship, upon respond number 2.
But there is no, oh, no, record was called for on 9/1.
Lordship.
So I think it is not received. But, Mr. You, Mr.
B. Kamdak.
You, Mr. B. Kamda.
On behalf of us, Gyatso. Gyatso.
Mr. B. Kamda, Yes.
Gyatso.
From the note of the registry dated 9/1/2024 and 11/1/2024, it is seen that the case, the LCR, scan copy of the LCR as well as was called for from the concerned court, and the notice was also issued to the respond number 2. But neither the scan copy of the LCR nor the service report on the respond number 2 has been received. So issue reminder to the learned court below. And registry will take appropriate steps for calling the case scan copy of the LCR, and service be awaited till next date of listing on respond number 2. So can it be expected by 1 week, 2 weeks? Because
Okay,
it is a very matter.
Lordship, then 1 week, Lordship, we'll see if it is not come, then.
Matter will be listed after 1 week. But
my
I
lord-
cannot fix the date, I think, because don't know,
The service has also not been completed, so only on after 1 week, Lordship.
after 1 week,
Yes, sir.
and the date to be fixed by the waste.
Yes,
And
sir.
if you receive by that time, and the LCM, keep it clear. And then,
Lordship.
okay.
Most obliged. Your lordship,
Number 7,
7. This is a AB application, pre-application.
AB.
Yes.
In this, on 24, the CD was called for Lordship.
Who is appearing on the sixth? Mr. Taro, you are appearing? Oh, you are appearing? CD,
Lordship, yes, we have received a CD. Lordship.
most probably up to date CD was called.
Lordship.
Have you received?
Yes, I have received. Lordship, and the CD, Lordship, the objection is there, Lordship, because the accused person has not appeared, Lordship, which was called on, Lordship, 29/1, Lordship. Because, Lordship, the order was passed on 24/1/24 to appear before, Lordship. So this is the CD, Lordship.
Let's see, on the last occasion also, because your interim order was in fact
Yes.
passed on 9/1/2024.
Yes.
And it was fixed on 24.
Yes, Lordship.
And 24 also, we made an observation considering your submission that he has already
Yes,
appeared,
yes,
so and so.
yes, Lordship.
But again, for that is the reason we sent back the case diary, calling for up to
Yes,
date
Your
case
Lordship.
diary. But again, the same thing is what?
In this case, Your Lordship, this person was asked to appear within 3 days. On 24, the order was made by this Honorable Court, Your Lordship. This person appeared on 25, as per the instruction received from me, Your Lordship, from the, he tried to receive on 25th. As there was on 26, it was holiday. Also on 27, he tried to receive. I think the IO has not make a statement of him, Your Lordship, in this case, Your Lordship. But
No, as per your instruction, when he appeared?
he appeared on 24, this Honorable passed an order to appear within 3 days of January 24, Lordship. On the very next day, he appeared on 25. Again, he tried to appear on 27 because 26 was holiday. So he tried his best. And I think even he disclosed his statement, whatever he knows, Lordship, in this case. As per the instruction received from this applicant, Lordship.
Then what to do? Your statement is not available here. Or is there any bail bond? I think bail bond is also not available.
Bail bond I have executed before the CGM, Lordship.
Before CGM? What? Before arrest, where have you appeared before the CGM? There was no such direction that you have to appear before the CGM and to file your bail bond.
If we go to the order of 9 January, Lordship.
9/1.
9/1.
Yes, that is the order of 25,000 you have
Yes.
given bail.
Yes, sir.
So the satisfaction of the arresting authority only. Arresting
sir.
authority means before IO.
Yes, sir.
Under what authority or under what order you placed your bail bond before the CGM? There's no point to appear before the CGM because you are not got arrested in this case till now.
Yes, 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 sir.
Then what to do?
So then,
Similar kind of order we cannot pass because on the last occasion also considering your submission only,
Yes, sir.
I made an observation that yes, may not be also that is the reason within 3 days you were asked to appear before the so and so. But in spite of the fact, again, if we call for the updated case diary and today also the same.
This is the instruction only I have received from the alleged
Then
accused
what to
person.
do?
Because he
See,
had
the
tried.
last occasion also we given a time and like,
No.
again, this time also same report is there, further date is till 29/1/2024, your is not appeared. What to do?
Lordship, because 26 is a holiday, Lordship, and Lordship 27, the Lordship, if they have appeared, Lordship, then that should be reflected here, Lordship.
Now see, for
Lordship.
police station, there is no holiday.
Lordship, that's why,
For
Lordship.
you, there is no
Right.
holiday.
Yes, sir.
It's a
The
court
26
work for
Lordship.
other office business, there
Lordship.
may be holiday, but office for the police station, there cannot be any holiday. 26, 27, 28, whatever, all are
Lordship. But
24 into
26
7. So there cannot be any holiday
Lordship.
before police station.
If
Or
26 we
may-
can
you may
consider
not
because,
need any specific date or working day to only the working days to be appear before the student. So it will be because it is a police station. only.
26 we can consider because it is a Republic Day, Lordship. Other days, 27 he can appear, Lordship. And they have the CD, Lordship, the status report, Lordship, they have not appeared, Lordship.
Yes, they have not appeared. Otherwise, we have to cancel your bill. We don't have any other alternative because in 2 occasions you have given the opportunity to appear before the. I considering your submission, I have made a observation that yes, maybe.
But this person had tried many times before also on.
What has happened?
on
You have you do not have any other instructions also that he tried. Why he was not successful? It's not kind of anything is there.
if we go back on the 9th of January also,
Huh.
on 10th, he also appeared. For him, there is also order was there also. But he have tried his best and disclose whatever he knows in this
Is
case.
there any observation made by Lucy? Let's check. We'll check this one. If there is any that you have appeared or tried to give your statement, then it's okay.
Lordship, statement is there, Lordship.
Hmm.
Lordship, question.
What is your name?
Gida Panya, this applicant. Yes.
Gidapan.
Oh, your statement is there too.
Lordship. Yes, sir, Lordship, this statement is on Lordship for the, when the interim was granted, Lordship.
When?
After that, Lordship, after that, Lordship, as per this status report, Lordship, again, he was called for Lordship.
Hmm.
And that time he was absent, Lordship.
Oh, achha.
Maybe for some further interrogation, Lordship. He was called for on 24, 25, Lordship. Because Lordship, on 24, Lordship, updated CD was called for and interim was continued. As per this order, Lordship, of the Honorable Court.
Yes. On 24, there was instruction to appear him on within 3 days.
Hmm?
On 24, there was order passed by this honorable court to appear before the police station within 3 days or so.
Okay, and the last occasion also we have observed that observation.
Yes,
that
sir.
he was not cooperating.
Lordship.
On 10 you appear.
Yes, on 10 I have
Thereafter you are
appeared.
not cooperating. If you are not cooperating or violating the order passed by this court, the conditions of this court, then you don't have any.
Otherwise, Lordship, if Lordship, as per his statement, Lordship, he was already there and that statement could not record it. Then Lordship, another Lordship, the last chance may be given. So 3 days, within 3 days, he may appear, Lordship. And Lordship, after that, Lordship, we also, take the instruction from the IL, Lordship, whether the interrogation complete or not, Lordship. On the basis of that, Lordship, this bail may be, Lordship.
But on our part also similar kind of order. we
Lordship,
passed
this
similar
is their
kind of
Lordship.
order. It is not our duty to cooperate in all the time, no? To take the instruction, you're not taking any proper instruction from
I
your
have
client.
told him to
He is
appear.
enjoying the benefit of the privilege of the PRS bail.
I have
And you are
already
not
told him to
cooperating,
appear.
you also. Because you're not in a position to get any instruction from your client also.
Your Lordship.
So then, why should we give the opportunity? Tell me, otherwise we'll reject the bail petition.
And moreover, this accused person is from domicile from this localite of this area only also.
Hmm?
This accused person,
Oh, that will be sufficient enough. Find the same kind of order, no? You Mr. Vitaba?
yes, Your Lordship.
Heard Mr. Vitaba Lal counsel for the petitioner and also heard Ms. N. Hadi Lal petition PP, appearing on behalf of state respondent. It is submitted by the learned additional PP that up to date case diary has been received. And with a note from the IO that the accused person has not reported before the investigating officer till 29/1/2024. And thus he violated the order of the court dated 24/1/2024. However, she submitted that one statement is available in the case diary, which was recorded by the IO on 10/1/2024, but thereafter, even repeated call, he did not cooperate the IO in the investigation of this case. Next, in this context, Mr. Taba, the learned counsel for the petitioner, has submitted that he, after obtaining the order on passed on 24/1/2024, he again tried to approach the court on 25th.
Yes, on
Then 25th, what had happened?
he appeared before the police station Daimok also.
And then
As
why
per the
his
ins-
statement is not recorded?
as per the instruction received from the accused person, the IO has not accepted his statement, I think.
Accepted?
Yes, his statement was not recorded. As per the instruction received from the,
As per instruction from his client, he appeared before the IO on 25th of January 2024. But his statement is not recorded by the IO, and thereafter, due to on 26 and 27 being holidays, he could not appear before the police station. However, he is ready to appear before the police station within 3 days. if he allowed one more chance to appear before the IO. Considering the submission made by the Learned Counsel for the petitioner and the additional people, the petitioner is hereby directed to appear before the IO within 3 days from the date of order. And if he fails, if any reason if he fails to appear before the IO, the consequential order may be passed accordingly. CDB return with asking to calling and CDB return and call for the up-to-date case diary fixing the matter. And yes, right.
Lordship, 7 Lordship. 7 Lordship, 7 of
7-2.
Much obliged.
This time you get your instruction, otherwise such kind of submission will not go on.
Yes, Your Lordship. May I, my lord? My lord, may I please, my lord? No,
24.
yes, my lord. This item may be passed over for timing, my lord.
Now see, question is timing will be difficult on our part today because we have a interview from 3, so by 2:45 we have to arrive. But timing will not.
Yes,
Why
ma'am.
timing?
Because my senior Mr. Tiri Tara, my lord, he's engaging on court 1. Just for timing.
He's arguing a matter in court number 1. The moment he finishes, my lord, we can take up the case. All right.
May I please, Your Honor? I'm on behalf of the leading counsel, Talin Dukam sir. Due to his health is serious in condition, so he unable to appear and may pray for the adjournment. And also
16.
item 16.
What you have submitted?
The main leading counsel, Talin Dukam sir, is illness and sickness. For that condition, he unable to appear before this honorable court and pray for the adjournment. And same is we convey to the
Who is the leading counsel?
Talin Dukam. T Dukam. Same is already conveyed to the opposite counsel also.
You are Mr.
Mr. M. Bagra.
Had Mr. M. Pada, the Learned Counsel appearing on behalf of the senior and guest counsel, so and so, and submitted that he is not keeping well.
No, Your Honor.
He is not keeping well and accordingly paid for an adjournment.
Someone.
Where the learned additional PV, Mr. T.A. with no objection. Full stop. It reveals that scan copy of the answer has already been received. Let the matter be accordingly listed in the admission column and can be listed.
Yes, Your
Or
Lordship.
is there any problem?
No, Your Lordship. It's a joint petition only, Your Lordship.
Huh?
It's a joint petition only, Your Lordship. Actually, perhaps, Your Lordship, the LCR was LCR was called for.
LCR has already been
Then
listed.
it may be list for admission.
Is the matter on admission hearing. After 1 week, or
Okay.
he will be in a position to appear before after 1 week, or
No issue after 1 week.
after 1 week he can.
No
After
issue.
1 week, if we go, they're not going to fix any date. No want to end the date fixed.
No any fixed date given.
Not
Give any after 1 week.
Yes, after 1 week, at least to be fixed by the waste. Okay.
Yes, definitely. Deep oblige, Your Honor.
Oblige, Your Lordship.
Lordship.
Here, Your Lordship, on last occasion, CD was called for. Basically it's a joint petition, Your Lordship. But Your Lordship, the matter has been culminated to charge sheet, Your Lordship.
During the pendency of this.
Yes, Your Lordship.
matter.
It has been charge sheeted, Your Lordship.
So your petition was basically to, for quashing of the charge sheet.
FIR.
So,
FIR.
FIR.
Yes,
sorry.
to make
now
amendments.
charge sheet has been
Now-
filed.
Now I came to learn that it has been charge sheeted.
They have to make necessary amendment because they have to challenge
Oh.
this quashing for the charge sheet also, Your Lordship.
Yes, yeah. So earlier, no, the FIR was not charge sheeted, then I would file this application. Now it has been charge sheeted. So my application had to be modified.
Had Mr. N. Kazi.
Yes.
The Learned Counsel for the petition, also had Mr. T. The Learned Petitioner PP, appearing on behalf of said respondent. Scan copy of the, you have received the CD.
No,
Yes,
Your
sir.
Lordship, since it has been culminated to charge sheet, Your Lordship, only the response to the WT message has been forwarded to us that matter has been culminated to charge sheet.
It was a joint petition and on the last occasion, the CD was called for. However, it is intimated by the investigating officer that case has already been charged sheeted. First off. In that context, Mr. N. Tajir Ilani, the counsel for the petitioner, has submitted that some modifications / amendment will be required in the present petition, and accordingly, he will file necessary amendment petition in a form of interlocutory application. Accordingly, and praise some more time to enabling him to file the necessary amendment petition. Fair allowed, let the matter be listed accordingly after 1 to 2 weeks or
2 weeks.
let the matter be listed after 2 weeks, enabling the so to file the interlocutory application seeking the necessary amendment. You want now LCR, can copy of LCR can be called for? Or
Your Lordship, they have not bring it into the record whether the charge sheet has been not been there on the there or not, Your Lordship, because they are challenging the FIR. They have to bring it into record first. Then only, Your Lordship, after allowing the amendment petition.
matter be listed after 2 weeks.
All right.
All right, Your Lordship.
Complaint number 18.
Your Lordship, here also it's a joint petition. Perhaps, Your Lordship, I find it difficult to sort out whether it's a joint or on merit they are approaching this court. However, Your Lordship, on last occasion, case diary was called for. Your Lordship, after my submission of my learned brother, Your Lordship, I will place some objection before Your Lordship.
My lord,
Otherwise, as per you, it is a joint petition.
my lord, this is a petition filed by the petitioner, the accused. The,
Petitioner accused.
yeah, my lord will find the impugned FIR.
No, first of all, clear me, it is not a kind of joint petition. It is, the petition is filed by only the accused person.
Accused person only. So we have made the complainant of the impugned FIR as respondent number 2.
That means on merit, Your Lordship. That means on merit, my learned brother will argue. Your Lordship.
So now you are the respondent number 2.
Yes, ma'am.
You are appealing for respondent number 2. Yes, ma'am. So respondent number 2 was the victim or claimant, whatever.
Complainant in the impugned FIR.
Your Lordship, you're invoking 482. What are the fundamental requirements has to be complied with? Initially, Your Lordship, if it is joint petition, then mutual settlement between the party. Secondly, all the party has to approach. And thirdly, the court will consider Your Lordship, nature of the gravity of the offences. And if it is on merit also, Your Lordship, they have to, Your Lordship, implicate all the parties, including the victim also, Your Lordship, the complainant and the victim, as per the Guwahati High Court rule, Your Lordship, criminal business.
Yes.
But they have not implicated the victim, only the complainant, Your Lordship. And victim names are clearly reflected in the FIR itself, Your Lordship. Your Lord,
He is the complainant only.
Yes,
Why have not made party? Are they the victims?
my lord, in the FIR, technically they are not victims. If we see their FIR in the FIR and the statement under 161 statement.
So those matters will definitely come later on. But what is their necessity is that the victim has to be made party. As we have submitted, technically he or she may not be the victim of this case, or maybe there may not be any such ingredients or materials also. But the question is that if one is shown as a victim in this case, in that case too you have to make the party. That is the issue. Otherwise, in the FIR also, where is the FIR?
page 19, Your Lordship.
19?
Yes, Your Lordship.
Case 19 is the FIR. May I read? With humble submission, we'd like to inform you that regarding ongoing APSU election 2022 to 2025, the student from Rangpura Government College, Changlang, numbering 15, were coming to Itanagar for its slotted 26th General Conference of APSU. With this today on 11 May 2022, around 7 to 8 p.m., the vehicle carrying the student delegate have been stopped on the way NH 415 nearby Hotel Raju Nirjule by the group of people around 50 to 100. They first block all the way by the vehicle and peoples. And after that, they threw stones and weapon to our vehicle with intention to completely kill us. And by pelting stones of stone toward us, we are all inside the vehicle caring for life to be safe, but there was no stopping. Wherein our 5 vehicles have been completely damaged, and this pre-planned attack, our driver Tagrut John, Tagrut Tate, and Tagrut Taka and Tagrut Talik were grievously injured, and some are in unconscious state.
See, there may be technically may not be victims or whatever you have submission, but it's a clear allegation that three numbers of drivers, they were sustained injury, and that is the grievously injured by the accused or whatever. So that is there in the FI itself. So name of 1, 2, 3, 4, 4 are there.
Your Lordship, and not only that, Your Lordship, 3 girls are also there in the last para, Your Lordship. May kindly see. And among the attacker, 1 have been clearly identified so and so, residing as so and so. After the attack, we came to know that the delegates were carrying namely so and so and so and have been abducted by so and so.
My lord, this will be clear in the counter FIR against this impugned other FIR. There is a counter FIR filed by the General Secretary of the Rangfra College, who is in charge of carrying the delegates from the college. So he was the supporter of the one of the aspiring candidate of the APSU president. So my lord will see the counter FIR also before.
It's okay to made the party. Yeah. Is any other submission? Because they are from the FI itself, which reveals that there are 4 numbers of injured person, and that apart as pointed by the learned additional PP, apart from those 4 injured, there are 2-3 numbers of girls who are also there, who are alleged to have been abducted by these ones. So it's a clear case where the victims are there. Maybe there may be a resolution, there may be an amicable settlement, or later maybe case may be a fit case for quashing and all. But the question is that there, and even after receipt of the notice and all, if they remain silent or it did not appear, then definitely case may be hard. But initially we have to make part.
Because my lord, in this case, against this FIR, there was also counter FIR, and both the impugned complainant of the impugned FIR and the counter FIR, they have already settled the cases outside the court. And whatever minor injury.
FIR, it seems, but we need the settlement is. Hard Mr. You are Mr.
T. Sunil.
T. Sunil, the learned counsel for the petition, and also hard Mr. T. The learned additional PP appearing on behalf of a state respondent, and Mr.
T. Nega.
T. Nega, the learned counsel appearing on behalf of state respondent number 2. However, it is submitted by the learned additional PP.
Your Lordship, this may be reflected in the order, Your Lordship. The criminal business chapter 11, where the Your Lordship, implement of the victim and the accused has been clearly given. Chapter 11 of the Your Lordship, Guwahati High Court rules, criminal business, Your Lordship. 1A.
Criminal?
Business, Your Lordship. Chapter 11, criminal business, A, general, rule 1A. There it has been provided, Your Lordship.
However, it is submitted by the learned additional PP that from the FIR itself, it is seen that there are 5-6 numbers of the victims who are not being made party in this case. And as per the Guwahati High Court civil criminal rules, the chapter 11 of the Guwahati High Court criminal rules rule, and as per rule 1A, all the victims as well as the informant has to be made part, should be made party in a case. But here in the same case, it seems that despite of the mention of 5-6 numbers of victims, none of them were according to submitted that those were necessary party for passing any of the presence. Considering the submission and here additional India were directed to make all the victims in this case, and filed in that paper, seeking necessary amendments.
2 weeks.
Let the matter be listed 2 weeks and I think that she will to find the necessary amendment petition in the form of
Your Lordship, CD may be returned at this stage. It's the original one. Deeply obliged.
Let us see, matter will be most probably maybe settled as per him also. I'm thinking that it was I mean, this is students and also group was there, so there may be a supplement. I don't disagree with you. But go by the proper procedure because tomorrow it may be a question that how in spite of mane, in absence of the victim, how the matter has been settled. So there may be an issue.
Yes, my lord will cure the some procedural irregularities
Yes.
and file it again.
Obliged.
Yes,
Because if it is already received. Because
But not
date
received,
put
yes.
by the IO, you cannot believe how or what penalty they can put. If it would have been received by the office of the special PP or special or by the even in the PI court also, in that case matter definitely would have been different because in that case.
My
We'll
humble,
see the matter.
yes,
I'll go by the record also.
yes, yes. My humble submission will be pass any appropriate order.
Grateful, Milad.
Obliged.
Please, your lordship, there's an appeal under order 43, rule 1 and 2 against the order rejecting my application, my petition under order 9, rule 13 for setting aside the ex parte order. Lordship will find the impugned order against which I have come is at page 30, page 13,
1-3.
1-3. 1-3. The present missed case was heard on this days. The lordship will go to the later part. It's in the case the petitioner defendant number 1 referred to as the applicant that until the receipt of the show cause notice of the on 25/2/2023 in execution petition number this in money suit corresponding money suit number this, summons were never received by the applicant. Further, it's pleaded that as per para 11 of the judgment, it appears that on 27/11/2020, notice were issued to the defendants for filing WS on 15/1/2022, but the defendant remained absent. Though the plaintiff respondent had taken steps through prepaid registered post and by order dated 15/1/2021, leave was granted to the plaintiff respondent for publication of the newspaper, which is accessible by the applicant and the defendant number 2, and the case was posted on for appearance on 13/4/2021. The plaintiff had accordingly published the notice in 3 newspapers, namely Sentinel, Doinik Ahom, and Echo of Arunachal Pradesh. However, the applicant defendant failed to appear despite the publication, and accordingly the case was proceeded ex parte against the defendants as per order 9, rule 6(1)(a) of the CPC, and ultimately the suit was decreed ex parte in favor of the plaintiff for recovery of a sum of rupees 1,72 lakhs and odd, only together with interest at 6% per annum from the date of the decree till realization. It is pleaded by the applicant that the applicant respondent had never received summons from the court in the money suit number 39 of 2020, and as such, the question of appearance does not arise. Further, it's pleaded that the applicant neither is a subscriber of the newspaper, the Sentinel, Doinik Ahom, and Echo, nor the applicant had notice of the paper publication. As such, the applicant could not appear on 13/4/2021. It is further pleaded that the service of summons as per Order 5, Rule 21, and the publication of notice in newspaper under Order 5, Rule 20 is not tenable in law as the applicant is still unaware of which issue of the advertisement was published, and the contents of the contended that the applicant neither read nor subscribed to the newspapers where it was published. It's further contended that had the applicant received the notice to which was
So prior
which
to the publication of notice to newspaper,
yes.
was there any other report that you have received or written
No,
back?
Lordship will find that, the suit was filed, they, even before the notification order was passed, the plaintiff never produced the tracking report to show that the registered post had received. Lordship will look at the order. I don't know, the records have not come. Where's the newspaper publication? The order where newspaper publication was given. I don't know, we had, the scan copies were called for, but anyway, it's an extra copy, extra set. I don't
we
have
have,
extra.
We have not received this scan copy.
The
LCR was called for. Scan copy of the LCR was called for.
I don't think this. It
I
has not been
don't think it
received.
has come, it's not been there with the office note.
Okay.
Anyway, Lordship, I'll just read
Let's
to
see if
it.
it's not,
It will require it.
It will require. So let them, in that event, the records have to come, Lordship will require the records. Because I have to show the dates.
Yes.
It's relevant because they have not filed the
Because in the LCR most probably, why you need scan copy? Why they?
Actually, the entire
No,
NCR
actually, on the first occasion, whenever this honorable court was hearing the matter, so then court has called for the scan copy because there was no stay order
no stay order.
in this matter.
So now I think
As the proceeding was not stayed, therefore scan copy was called for.
so Lordship may stay the proceedings and call for the scan records. Short date, it's only from Alo.
But most probably nowadays it is a trend to call for the scan copy.
Yes.
But original is always better, Lordship. Original is always better.
No, but there
Or
are
if
some-
original is called for, then it's impliedly state the matter actually.
I know that court didn't want to do, but I'll pray for a stay also. For a short time, let the records be called for. Short date, regular records be called for, we'll finish off on the next day. I'm sure.
No, scan copy will suffice, I think, my lord.
Scan copy.
Not-
All the, if there is any report or if there is any, suppose, the report on the notice also, that will, everything will come on the scan copy.
If everything
We can-
comes,
we can go.
it's all
Yes.
right. Lordship may give us, fix a date. with
Now,
the
cases at the execution stage.
Execution.
Execution has already been filed.
They have
Execution
filed.
has already been filed.
Only then we got to
They
know.
were supposed to file the assets and liabilities, or not assets,
Assets.
yes, assets,
Not
list of
liability.
assets.
They know, only I have to file. Because Lordship will file, there's a lot of infirmities in the entire matter. In fact, the suit itself has been filed against a dead person, which is not maintainable. And Lordship, if the records are called for, I mean, scan copy or whatever, I have no
So,
quarrel.
we can do one thing, the matter is listed in the admission column.
Yes,
Well,
Let the matter be admitted for hearing
my lord.
yes.
and scan copy of the LCR be called for. But the question is that matter has already been in the execution stage.
Yes.
So we don't give much time for the probable, where from it has to come?
Alo.
Alo. Alo is how far from here? Huh? 320 kilometers. Still, if scan copy is there, then we can reach by 3 weeks or 2 weeks.
Yes, Lordship, definitely.
2 weeks, like we can reach, no?
Yes.
Otherwise, because if his execution is over, then I don't know.
Lordship, then the
No,
execution.
execution is not over because
No,
they
no.
took time in the
Obviously.
trial court. They took time that they have filed an RFA here.
So
And court has fixed it as necessary order.
obviously, Lordship, I'll take time because if the execution is done, what is the
Then
great
we
purpose?
can do one thing, in that case, to save this, the other party, we can make an observation, then stay matter will be heard on the next day. In that case, they will be a bit in
Yes,
good
absolutely.
position, I think.
I see,
My
because
lord,
otherwise,
I think there will, I think that will not required because
already the matter is fixed for necessary order.
Whatever it is, let everyone feel safe. You see, who is at the,
No.
I'm at the receiving end, so I need safety. So
No,
Lordship,
I am the receiving end. I am not getting the execution part.
that,
Decree part I help.
that is if you get also, it's a bonus. Lordship, let the matter stay on.
Ma'am,
Your
it's
condition
it's
that
not
they
a
have
bonus,
received-
my lord.
That
It
will
will
come
be-
to it later.
It's a due.
When the suit is not maintainable, yes.
Suit is maintainable, and suit is whether suit is maintainable or not, that will not decide by the honorable court in this
No,
matter.
definitely not. Definitely not. Only whether this order 9, whether it should be set aside.
That is the issue.
That is the issue, and Lordship will fix a date, a short date. I am quite okay with any date, Lordship.
And one more
Only
thing,
after the
It
14th.
seems to be, you're quite okay.
I'm quite okay with any dates, Lordship.
and one more thing, I would like to point out, my lord.
Yes.
This there is some
Nomenclature.
nomenclature. Yes, that is regular first appeal, but it
It
should
is
be
FA.
first appeal against order.
The
because-
regular has
MFA should be there.
FAO.
FA only. FAO.
Yes, yes.
FAO.
If it is RFA, why it is RFA?
No, it is my fault. The office. has
Actually,
to-
on the first, means the matter was filed under Order 41 Rule 2. Then they have registered as RFA.
So
But
now I have converted it.
on the very first day, when
What
here
is
was,
the process of conversion?
they have amended the part. And in that amendment, the nomenclature
Would also say it'll become FAO. The office may change the nomenclature.
whether office may change or not, I don't know.
I'm
Yes,
I'm also.
nomenclature-
Registry may, registry might not.
That is the decision of the Supreme Court. Nomenclature is not important. If the court has the power, be whatever nomenclature a court can take up. These are technicalities which should not come in the way of justice.
Later on, that will may.
So
Yes.
office may correct it, Lordship.
Heard MSM Hajarika, the senior counsel, assisted by S. Newar, the learned counsel for the appeal. Also heard Mr. B.M. Dekar, the learned counsel, appearing on behalf of respondent Carriator. Decision, your order against?
No, এটি কোর্টে করে দিলে হয়ে যাবে নহলে পিছত দিগদাৰ হৈ যাব পাৰে মানে এনি এগ্ৰি পাৰ্টি এছএলটি যাব লাগিলে দিগদাৰ হ'ব
SLP gole I will also be there, na?
SLP যাব নালাগে, Lordship. SLP যাব নালাগে. ইয়াতে we are good enough. We are good enough here, Lordship.
Okay. This one, actually, this is the wrong, regular. Actually, your thing is also this regular first episode. That is why they have. also-
Yes, also the office may correct the.
and even their certificate is also wrong. In their certificate, they have stated as certified that the above grounds and the substantial question of law are grounds. In FAO, there is no substantial question of grounds.
It's not required.
This ground is not required. Actually.
The certificate is also wrong.
Certificate is not required only.
Required.
It's not required.
So from the cost title of this memo of appeal, it reveals that the case is filed under 41 under order 41 rule 1D and 2 of the Code of Civil Procedure as a regular first appeal, and accordingly it has been registered by the registry as RFA. But hearing the submission made by the learned counsel for both sides, it is seen that the present appeal has been filed only against the order dated 30/6/2023 passed by Civil Judge Senior Division, West Siang District, Alo, Arunachal Pradesh, in this case number 12/2023, in connection with Manisud 39/2022. So, considering this aspect of the case, and also considering, and after hearing the submission made by the learned counsel for both sides, it is seen that the cost appeal there's a need of amendment or modification in the cost title of the memo of appeal, and it should be registered as a FAO, not as a RFA. And accordingly, the registry is hereby directed to change the nomenclature of the present appeal. So I don't know whether registry has the authority or you can.
No, registry has to, registry.
Registry can
Registry has to do it.
accordingly be registered, so and so. Next paragraph. Further, considering this submission made by the learned counsel for both sides, the matter is admitted for hearing. I'm not going to detail of the case.
No.
Admitted for hearing. Call for the scanned copy of the LCR, and matter may be considered and full stop. As the execution case has already been initiated, let the matter be listed after 2 weeks.
Also, the date may be given. Date may be given.
Date. After 2 weeks, can you give a date? Huh?
15th or 19th.
No, 19 is a working day, na? 20 is a holiday.
20th is holiday, so 19th is fine. If it's, I mean, I am all right.
It's Monday, right? Monday.
Yes,
Okay,
Mr. Deka, 19.
okay. My lord.
19. Visit again in Olacheparis.
Thank you.
Lordship?
I'm here till for 2 weeks, last 2 weeks.
Yes.
And
Yes.
this is
So,
the second week.
so you're coming back again 19th.
No.
Today my train got late more than 6 hours.
And Lordship,
I rushed from the station directly here.
and Lordship regarding the interim.
Huh?
Regarding the interim, my interim.
I'll make the observation there. On the, if the LCR will not receive on the next date of listing, the stay matter may be heard accordingly. Okay. So 19 is will be date.
Much obliged.
Item number 24.
Item number?
My lord, kindly pass over below, sorry.
No, I'm not confirming. It's already over.
I'm doing
No, this is already over. 20. Yes, 24.
Yes.
It was fixed on yesterday.
Yes, my lord.
Yes, my lord, I have filed my power. One of my brother requested me to appear for him. My lord, this bail application was filed without copy of the FIR. Without copy of the FIR. This bail
Copy of the.
FIR, only on the basis of summon. That is, my lord is aware that judgment, Gurbakh Singh Sahiba's 1982 supply, page 5,
No, yes,
apprehending.
Gurbakh
Yeah,
is there,
yeah,
but
yeah.
the question is that at the time of filing this so and so, no FIR was lodged against you.
No. Even
So
I
now
was.
what is the position?
No,
Is there any?
No, my lord, I was not.
FIR
Before-
was lodged.
FIR is lodged.
Yes.
No, at the time of filing the application by the petitioner.
Yes, it was already lodged.
It was lodged.
And
Lawful.
2020, my lord,
Oh.
because
Baby,
I was.
So I thought that
No, no,
saying,
no,
Gurbakh Singh, if an FIR is
Yeah.
not there, then in that case
Yeah, yeah.
also anticipated bail is applicable. I thought that in that process. it
Yeah.
is there.
Yeah, no, well,
Anyway, FIR is there.
yeah, FIR is there, my lord, 2020, my lord.
Achha.
I was not named in the FIR, my lord.
Achha, you are not named in there.
And my lord, second thing, my lord.
Mm.
The main accused, my lord.
Mm.
One Mr. Mukunda Mahadev, MUKUNDA, Mukunda,
Mm.
MAHADAP, Mahadev.
Mukunda Mahadev.
Yes, Mukunda Mahadev, and one more, my lord. And those prime accused who purportedly gave those certificates, they were arrested and they are released on default bail, my lord. That is by the learned lower court, my lord. The copy I do not have, my lord. Just my instruction is, and my brother, the special PP for the SIC will also will also conform to that aspect. My lord, before that, my lord, kindly have my additional affidavit which I have filed this morning.
Have you received the copy?
Yes, ma'am.
Yeah.
Because why I was forced to file this because they may say that I am not cooperating with the investigation. My lord, pursuant to this, kindly come to page 5. Pursuant to the privilege of pre-arrest bail extended to the accused on 6/12/2023, my lord. I have appeared before the IO, my lord, in a chronological order. My lord, page 9 is the forwarding of the bail application, bail order. Then, my lord, page 10, my lord. On next date, it's 11, my lord, I appeared. Then, my lord, 12 also, I,
Judgment was passed on, okay, order was passed on.
order 6/12, my lord. My lord will see next page, my
No,
lord.
your anticipatory bail was
Oh.
granted you on 6/12.
So 6/12. 6/12, my lord. On their summon, I appeared, forwarded and appeared, my lord. My lord has seen that on 11 December at page 10, my lord, I have appeared. Then, my lord, page 12, 11, my lord. Again, I have appeared on subsequent date, my lord, 12 December. This is third, second. Then consecutively on 3rd also I have appeared, my lord, at page 12, my lord. Then page 13, my lord, on 14 December, my lord, 2023, I appeared. My lord, 15 December also I have appeared at page 14. 18 December also, my lord, I have appeared at page 15, my lord. Now, my lord, page 16, after 18, a gap of 6 days, 8 days, I have again appeared on 26th December, my lord. Then 2nd January, I have appeared again, my lord. Now, my lord, next page, in order to show that the date of my attendance before the SIC. My lord, I agree that these kind of offense are serious in nature, my lord. Whenever there is a invocation of section 13 of the PC Act, read with 468, 471, 420, they always does it, my lord. Now, considering the gravity of the section as invoked against those people, and though I was not named as an accused in the FIR, during course of investigation that they came, the investigation also found that there are my involvement. So therefore, I have been summoned and I have been appearing before them pursuant to the privilege of interim bail granted to me on 6/12/2023. And consequently, I have been cooperating with the investigation. Now, my lord, second limb that I'm on the fact only, my lord, second limb is that the main accused of the entire scheme, the SIC arrested, and it was 22nd December, my lord, my instruction is 22nd December, my instruction is that they were enlarged on default bail, my lord. Default bail, my lord. Now, the main accused are on default bail, my lord, and they are also cooperating with the investigation. So now, in view of numbers of my appearance, my lord, number of my appearance 1, 2, 3, 4, 5, 6, 7, 8, my lord. 8 occasions I appeared. I was interrogated for more than 6 hours every day. Now the question comes, case diary will always say that the accused is not cooperating with the investigating agency. Rather the accused is intimidating the IO. That is figment beyond the no stretch of imagination. accused before the police personnel can do like that. But normally, in order to get the bail rejected, the police will always write that. No? So therefore, my lord knows the concept, what is the law laid down there. So therefore, my lord, my respectful prayer in view of my cooperation extended to the IO of the case, and I will continue to extend my cooperation to the IO as and when I'm called for, and I am a local resident of this state. I'll cooperate with them at any point of time. So my lord, kindly regularize the bail. That would be my only submission. But I don't know my brother what he would say. My lord, I have the CD, madam. My lord, this case pertains to illegal appointments of nurses, my lord, ANM and GNM.
One for engineer, one for literature paper, one for
Now-
nurses, one for
Yes.
teachers.
Even the Public Service Commission, the engineers, everything. Now, this pertains to
Illegal appointment of nurses.
fake certificates, and there are two aspects here. Now, they were illegally appointed, and these appointees brought this certificate illegally, and they registered their certificate not in some in Arunachal Pradesh, some in Assam, with the fake documents. And there was
They have obtained the illegal.
documents, fake documents, fake certificates. And after having procured the fake certificates, GNM and ANM, they have again illegally, by giving money, enrolled themselves in the Assam Nursing Council and Arunachal Nursing Council, number 2. Number 3, having obtained that certificate of the council, they've illegally appointed themselves as nurse in the National Rural Health Mission, NHM. And it's true, my lord, the 2 accused, they were arrested and they were released on bail. Their statement has been recorded, my lord. If my lord, Peru's page number 42 in the CD, my lord. 42 page. Sorry, 142.
Yes.
This is the 161 statement of Mukunda Mahadev. This person, he is one of the main accused. He is the broker from Assam. He pertains to an advocate from Jalukbari. The accused person is a broker from Arunachal Pradesh. From
He is broker from Arunachal.
Arunachal Pradesh. He is the main broker. And as per his statement, there are so many brokers, my lord. But this present accused person has the largest number of illegal candidates. He has 22 numbers. 22 numbers of fake. He has given them fake nursing certificates. He have paid money for them to be enrolled in the Assam Medical Nursing Council. And he has facilitated these fake 22 persons to be appointed as nurses in the NRHM because he was working as a coordinator in the National Health Mission. My lord turns to page 151 of the CD.
151.
51. Yes, my lord. Since I don't have a duplicate copy, my lord, so it's right. 151.
Yes.
151, my lord, will find it serial number 3. Serial number 3, is the present petitioner, JK, Poon JK. My lord, on file at serial number 3, there are 22, there are 22 candidates, and each candidate he has taken 80,000. And total amount which he has derived is 17 lakhs. That is in the records, my lord, fine. And this is for the ANM and GNM certificates. And down below, in the next, down below, for registration in Assam Nursing Council, it's serial number 2, my lord will find 97,000. Now, next page, my lord, 56, 57 is the statement of the illegal appointees, my lord, the nurses, my lord. They've stated that they've given money. And as per the 80,000 was given to, the 17 lakhs was given to Mukund Mahadev. And he has also, from that, he has kept his cut and he has given to the other officials. But we are yet to find whom they have given. Now, page 56 and 57 says that these are the statement of the candidates or the appointees. They said they have given 1.5 each to the present accused petitioner. But out of 1.5, he has given only 80. The rest he has kept for himself because he being the broker. And 160 to 162 also, my lord, will find the page numbers, my lord. You will find the statement of the accused where they have stated how much money they have given. They've said some has given 3, some has given 4 lakhs for the entire, right from procurement of the documents, registration of the registering in the Assam Nursing Council, and for appointment in the National Health Mission. Now, as far as cooperating with the investigation, my lord, it's true that he has come. He has appeared 9 or 10 times. If, my lord, to come to the IA file by additional affidavit. Page 5 is the interim order, my lord. Pass on 6/12/2023.
Yes.
My lord, may kindly peruse page 6. Down below, may I read, my lord? The operative part of the, upon hearing the parties and considering that there is sufficient incriminating materials found against the accused, I am not inclined to extend the benefit of anticipated bail to the applicant at this stage. This was an observation of the Honorable Judge. However, considering that the accused applicant is undergoing treatment outside the state for chronic such chest pain and other ailment, and also considering that he has undertaken to cooperate and appear before the investigation and as and when called for, and he is ready to abide by in terms and conditions for his bail, and is also ready to furnish bail. And this was the observation made by the Honorable Judge. There are incoming materials, and it has been observed. However, the bail was considered only because at that point of time, because this is an application which was filed, which was the order was passed on 6/12/2023. Now, this is February, my lord. At that point of time, obviously, interim was considered only because he was having an health issues, my lord, and he was taking medication outside the state. Therefore, my lord, certain conditions were fixed, my lord. My lord, see page 8, my lord. Only on considering the health issues, on humanitarian ground, the matter was fixed after 6 weeks so that he can have proper medical treatment. It was just a humanitarian application. Now, February, today is, and he has appeared, he has taken photographs, he has appeared around 9 to 10 times in the, because he's fit. But at that point of time when this was considered, he was not fit. My lord, page number 292 of the CD, my lord. CD, my lord. The whole bunch, my lord, which has been 292. After 292, 292, my lord.
292.
Yes. Next page, my lord. There is a bunch. Yes, there is a bunch of. Yes, my lord.
Yes, yes.
Now, my lord. When this illegalities came into form, my lord, there was a fact-finding committee headed by the then Special Secretary, Health and Family Welfare, my lord.
Yes.
They have scrutinized, my lord. There was a 6-member committee. It was chaired by the IAS Special Secretary. And they have found that all these documents are fake. And they were terminated. And the bunch is the report, my lord, from each district and each. My lord will find in the column, those are all fact, my lord.
All of them.
Yes, all are fact, my lord. And my lord, after that bunch, my lord will find a copy, my lord. It has not been numbered yet. There is a report from the registrar, Assam Nurses, Midwives, and Health Visitors Council. He has also given a report that all those nurses who have registered in Assam are fake. It is a finding from the Assam. Now, my lord, I may not go into the legality, my lord already knows, my lord. Since it pertains to an illegal appointment and since a lot of money are involved, my lord, it has to be taken from a different perspective, my lord. Not from the conventional cases that we deal, in fact, like murders and rapes and whatever. But this is a case of illegal appointments, the PC Act, my lord. It has to be taken from a different view, my lord. Now, there are so many materials, my lord. If I go through the entire CD, my lord, it's so surprising, my lord, how that could have been done. And it's a case where the nurses, my lord, unequipped nurses, they have been given the health of the innocent people are at stake, my lord. I don't know, like how a person can think, like, to appoint, like, it's unthinkable, my lord. Therefore, my lord, at this stage, my lord, and my lord, as my learned elder brother has already said, why? Because, my lord, why I'm objecting to the bail application? He's not cooperating. Why? Because, my lord, he's not, apart from the statement given by the other, the accused persons, my lord, or the candidates, my lord, he's not disclosing anything. And he's denying that he has paid any money. But all the transactions are showing that he has transacted all those monies, my lord. And my lord, when this whole episode came into form, my lord, what this person did, he called all these illegal appointees, my lord. He called all these illegal, 22 numbers, called in a hotel, my lord, in Naharlagan, my lord, myself, in Hotel Riverview.
Hotel and entertain them.
No, and then he had a meeting. And they went to Guwahati. They met Mukund also. How to deal with it? Because it has been done.
And already meeting was held with this present accused petitioner.
No, he called a meeting.
He called a meeting with all the candidates.
Yeah, all the candidates.
And then
they discussed, and he was saying, but they had a meeting, and that has been disclosed in the CD. And then they went to Guwahati 2 or 3 times so that this could be solved. How can they solve it? It means that he's already tampering with evidences, my lord. Because these persons be the persons who will be depositing against him, my lord. So he's already tampering with evidences, my lord. And we apprehend that in the near future also he'll do that, man. My lord, the entire CD has been put in a brief status report, my lord. My lord, may kindly peruse, my lord, the amount and the candidate's name, everything is there, my lord. And why the bail has to be rejected at this stage, my lord? Because now, as per the investigation, my lord, we have only into Arunachal Pradesh and Assam. But we apprehended there's other documents which have been brought from other states, my lord. That has been, we are investigating that part, my lord. And last time also, my lord, I have argued, my lord. Since he is protected, he's been protected by the interim order, my lord. And he knows that he will not be arrested. So whatever questionnaires are given to him, he says, I don't know. I don't have any comment. I forgot. But what we are ascertaining is from the statement of the co-accused, my lord. So that's why, my lord, I say he's not cooperating. He has already tampered with the evidences, and we apprehend that he will tamper with the evidences in the near future also, my lord. Therefore, I vehemently object to the bail application, my lord. And it's a very serious offense, my lord. And we need to unearth, my lord. Now we have unearthed around 30 to 40, my lord. There may be hundreds of them. And we need to take everybody. And we not only want to terminate all those illegal appointees, my lord, but we need to know as to who are the officials who has done that, my lord, so that it can be deterred, my lord. Obliged, my lord.
My lord will only kindly mark one submission advanced by my brother. His favorite Chidambaram judgment has not been brought in today. But in any case, well, that statement, 17,60,000, which my brother has made a submission, it was handed over to Mukunda. And Mukunda also has kept his cut and given it to the other officers.
Yes.
So, Mukunda and other main accused from Guwahati, they are already indulged on default bail. So that is one parity comes, my lord, first.
Yes.
Secondly, my lord, I was a block data entry operator. And in 2016, I resigned from the post. 2016. Meaning thereby, there is a cutoff of my activities with the department. So the FIR, my lord, will see, FIR is lodged in 2020. So that is after 4 years of my resignation from the service. 4 years of resignation from my service. Then
You were a data entry operator.
my lord?
You were working as a data entry operator.
Data entry operator from 2013, my lord, to 2016.
From 2000?
Under,
No, 2013 to 2016.
block data manager. Block data manager.
Broke data.
Yes, sir. Block data manager. Sorry, madam. Thank you.
National Health Mission.
Yes, block data manager, madam. From 2013, I was appointed on contract basis. Then I have put in my paper in the year 2016.
The FIR was after 4 years of your resignation.
FIR was after 4 years. It is a natural case, my lord. I was not privy or nor I have access to any record to the department, whatever is. Now, my lord, the second limb of clarification is, since I do not access to the Medical Council of Assam or the college, my lord, my role would be very negligible in that part, because it is Mukunda and the another gentleman, Sailendra. It is their thing, my lord. So normally, my lord, in such a circumstances, what happens is, there is a snap of link. And my lord, I am reiterating that statement. Mukunda has kept his cut and given to the officers. Now, in that event, why the SIC is not after the Director of National Rural Health Mission? Why is not after the Secretary Health? Why not Director of the Health? I am a small fry in this, my lord. It may or may not. Big sources are there. So why I am being targeted, my lord? And that too, the
Yes,
FI,
any answer from your side?
that too,
No, no,
FI.
my lord.
See, all these
No,
officers.
my lord, we have
definitely
taken this
they are-
statement, my
they-
lord.
they
It
are
will be.
definitely involved in the arrests, otherwise the other, they will not have the such kind of thing, will do all these things,
Yes,
because the officers are involved, very much they are
Correct.
they are involved in this.
My lord, may kindly peruse the first page of the status report, my lord.
Okay, bro.
I'll not name them, my lord. The then mission director, the deputy registrar cum secretary. We have called them, we have interrogated them thoroughly, my lord. One has been found.
But if, my lord, now the another question
We are
comes.
doing it, my lord. We are doing our job.
Yeah. My lord, then another question comes. I know this, personally, I know he is posted as deputy commissioner now in a district, Siang district. Afraid of, he's a DC and the registrar. Then what about the act of those nursing council officers in Arunachal? You have not called?
They, most probably, the investigation is still under progress, and as per his submission.
No, my lord, that's
they are
why
on the right track.
my lord,
Okay.
with great respect, my lord, as I have already been cooperating with them, and then there's Sailendra and Mukunda is the main kingpin. Because I don't have, and then I am out of the, I have no connection, no privy to the documents of the department. Was there really an illegal? Was there any connivance? Well, anything, my lord, sometimes is being zeroed out. What happens is, my lord, practically I am speaking, my lord, within the law. See, sometimes what happens, my lord, we also transfer some money to some of the relatives. For what purpose, we do not know. And then that money, online transaction is there. And my relative takes, and he misuses the example. Sometimes they will say, Papa, 5,000 bucks is required for this purpose. Please send me. But when later on, when we come to know, actually it is not for that purpose, but for the other purpose. Say sometimes they buy. So therefore, my lord, on the marriage, my lord, there is nothing as such, my lord, kindly regularize, and then parity may kindly be called into in this case. Grateful.
My lord, I failed to submit one, I mean, as per the CD, my lord, it seems that, my lord, after all this episode, my lord, this particular person, he has changed his name, my lord. He has changed his name. So it was very difficult for us to find out because from the statement, we got a different name, and now he has changed it to a different name.
The
So,
present petition.
yes, ma'am. It is in the CD, my lord, in the status report. He has changed his name. So since it was registered in 2020, my lord, we have arrested, but then we could not find out who this person was. Because he has already changed his name to a different person. So this is the degree of, I mean, the illegality which has been carried out. So that aspect will also be taken into
That
consideration.
changing, my lord, sometimes what happens, this is happening, my lord. In Arunachal, my lord, there is one train now. What happens?
Frequent changes of name or what?
Yeah, including clan, my lord. Including clan.
That I don't, I mean, oppose, my lord. But then
my
why
sister-
after all this episode?
My sister, this Likha is also there. What happened is, 361 of my clan, due to displace during the course of migration, displacement due to course of the migrations, they were writing Likhas for 30 years, 40 long years. Now suddenly, when we started counting the generations of our clan has gone missing. And what had happened, all 361 of them, when we narrowed down the narration of the genealogy, then came to a conclusion that they are Taras. So that similarly, these generation also then they change those things. This is not for any other purpose.
And when we argue, my lord, since there are so many things in the CD, my lord, I forgot one more thing, my lord. In the entire CD, my lord, And the bail was given only on the ground, the interim bail was given only on the ground that he had health issues.
Yes,
my lord.
you have already raised it.
My lord, no,
But then, my lord, there is nothing in his CD. He has never produced any documents.
no, my
like
lord,
that.
still the health documents.
They have only made a statement saying that during the hearing they will produce, but then they have not even produced to the IA also.
No, no.
We have asked for it, my lord.
No, my lord, this is not correct.
No, no,
I
you-
have
you
all the,
already produced.
yes, I have already all the records.
Only considering that ground only.
Yes. Well, what had happened, the
But as of
cardio,
now, he's fit.
no, not Milord. He is still in Guwahati. Because of that cardiovascular thing, Milord, it risk anything, Milord.
And my lord knows, my lord, whenever a person has to be arrested, my lord, he will be taken to the medical. Maybe he's fit. Obviously, if he's not fit, we cannot take him into custody. My lord.
When I was a magistrate, the production was there, na?
My lord.
Directly production. If you see a person, suppose the way he comes up from the police van,
Hmm.
like from humanity ground also, you will think that no, this is the fit case to be bail should be granted.
My lord.
When suppose bail is rejected or remanded, he walks straight, immediately wants to get into himself by in the car itself.
My lord.
So now he's see. This kind of no, I'm not on your picture.
My lord, এনেকা হৈ যায় মানে।
And হৈ যায়.
হৈ যায়।
Anyway,
Yes, great.
Your
20,
Worship,
20.
no, in item 19, I failed to submit this one that respondent was two. Notice was sub, duly notice was sub, pro judice case,
In which record it?
item 19. And she was unregistered today. And item 19.
Item 19.
Milord, that madam says, since that Lombi, the counsel who appeared in the lower court, we have served the copy also, received it also,
Yes, received.
and acknowledged that for some health issues I would not be coming, but then I have nothing to do there because it is a examination of the legality of that judgment.
Anyway, my
As a
that means
part of- as a
respondent
part of
number
the
2 is
Appeared.
already sir.
Yes,
It's a part of
sir.
it.
Hold it then.
Yeah.
Okay, now 20, who is appearing? 20. Item number 20 is the criminal appeal.
Yes, my lord. Here I am
No, no, no,
referring,
just- You also appearing here.
No, actually,
Who is appearing
Miss
here?
Ginny was endorsed in this case, and Miss T. Ginny.
Oh, TGN was in.
Yeah, yes. She texts me that she was migraine attack was there today,
No, she is not coming.
not coming. She's suffering from migraine.
She is having migraine.
Migraine, yes.
But are you in a position to argue the matter?
No, I was just informed that because she's following the matter.
this is 12 times this appellant they did not appear. These are for the dismissal, my lord.
Appellant or-
Appellant counsel.
Appellant counsel?
Yes.
What appellant counsel?
I'm appearing for the respondent number 2.
You are for the respondent number 2?
Yes.
Oh, who is the appellant then?
Eight party wakalat nama, eight party
A.
report, my lord.
Bhattacharya, S.K. Deuri,
Yes.
M. Likha.
And on, my
You
lord,
know who is appearing?
on 8/12/2022, this court has directed me to inform the parties.
Deuri.
SK Deuri. I personally talked to SK Deuri. He said he is no more in this case. He is not going to appear anymore. And again, I have personally talked to Mr. J. Likha, who is the younger brother of the appellant's wife. He also told me that all the briefs have been taken away by the wife of this appellant. Now, they are no more in this case.
Now there are 4 numbers of names of 4 numbers of counsels are here.
Yeah,
One
SK,
S.K. Deuri, one Mr. A. Bhattacharya, and Mr. J. Likha, and
A.
Somila.
Bhattacharya and Somila is the junior of SK Bhattacharya. And
SK
including
Devi.
this M. J. Likha. They all are,
So as per you, the advocates whose name has been reflected in the call list, they are no more in the case.
they are no more ready to, because all the briefs have been taken away by
Do you
the,
have any information otherwise that whom they are going to appoint the, because it is not a jail appeal, no? It is not a jail appeal.
Not
No.
Jalal.
Today, the 12th times, they did not turn up. As per the
But,
order,
the
my
question
lord,
is that once appeal is admitted for hearing,
Yes.
then
It
has
cannot
to
be dismissed on default.
Merits only.
Yes, it cannot be dismissed on
Otherwise,
default.
you don't have any way, simply you cannot dispose it.
of course, my lord.
Definitely, it will be heard on merit and accordingly decided.
Yes.
And till now, we don't have any information or intimation as to why the names of those advocates are being withdrawn or, and they have not also informed us, the council.
Yes.
Because once they have engaged, suppose by the Wakalatnama and all, it is duty bound of the accused, advocates, to inform the court actually.
Yes.
But they have not informed us. The court are not being informed by those 4 advocates. Or you can do one thing, if there is any such kind of position that they are not in a position to conduct with the appeal, or the brief has already been taken by the wife of the appellant, suppose.
Yeah.
In that case, they can inform us, inform the court.
Yes, yes.
Otherwise, how can we?
So I personally approached Mr. J. Likha. You come to court and
Yes,
inform
you
the
should
court.
come to court.
At least.
Otherwise,
We are suffering, my lord, here. Since more than 13, we are affaring, and other my party, they are also affaring, but the affaring they did not. My lord.
No, I'll pass the order itself now,
Yeah.
because even hearing is not possible.
Yes,
So
my lord.
let us see, okay. Heard, none appears on call for the appellant. Also, however, Mr. Antaji, the learned counsel appearing on behalf of respondent number 2, and also heard Mr. G. Tado, the learned additional PP appearing on behalf of state respondent. It is submitted by Mr. Antaji that since last 11 or 12 consecutive dates, the appellant or the learned counsel for the appellant remain absent without any steps. From the record also, it reveals that on the in several occasions, the appellant remain absent, and it is submitted by the by Mr. Antaji that he had a conversation with one of the engaged counsel, Mr. J. Likha, and it has been told that the none of the advocates whose name has been reflected in the cause list are presently engaged by the appellant, as the wife of the appellant had already taken away the brief from the engaged counsel.
Yes.
Full stop. However, it is necessary to inform the court by the learned and his counsel if they are not appearing further on behalf of the appellant. Other full stop. Paperwork is also ready and case is otherwise ready for hearing. Let the matter be accordingly listed. So can you just let necessary otherwise?
My lord, I can inform J. Likha also, because we are known to each other.
Let the matter be accordingly listed on, it is a 19 matter, no?
Yes, sir.
Matter be listed up to 2 weeks, enabling the learned counsels for the appellants to intimate or inform the court. Enabling 2 weeks, and in event of the absence of the appellant, the matter may be heard and decided on merits. On the next date of appearance, matter may be heard and decided on merits, even in absence of the appellants.